Hello, hello. We're just letting everybody in. It's just at 1 o'clock now, Eastern time. Good afternoon to everybody east of the Mississippi and late morning to those of you who are to the west of us. I would love to know where people are from. Why don't you shoot it into the chat while we're waiting to get started here? We will start in about 2 minutes. We're still admitting people. Iowa, Denver, West Virginia, Detroit, Pennsylvania, outside Philly, Delaware, Pennsylvania. Lots of neighbors today, Kayla. Awesome. We're going to get started in about 60 seconds. We are definitely enjoying a last blast of summer here in Northeast Ohio, where I am right now. Hopefully you're all having great weather too. It's always fun to see a little bit of extra sunshine in September before the chill starts to show up here in Ohio. All right. Well, it's 1:02, and I want to make sure that we are respectful of everybody's time. So I'm going to share my screen here as I say our general welcomes. Welcome. Thank you for making time today to spend with us to talk about readiness for a potential transaction in your agency's future. And what I've really enjoyed about putting this session together, which is a part of our agency owner Q&A sessions that we do on a quarterly basis here at the firm, is that a lot of what we're going to talk about today is useful to those of you who just would like to also maybe get a handle on getting your legal house in order for other reasons at your agencies. And what I mean by that is a lot of this is foundational to just having good legal governance of your businesses and also putting yourself in good shape in terms of contract readiness for your next client transaction, your next contractor transaction, because all of it kind of knits together in terms of being ready for a potential M&A transaction in your future. And so I am going to get my slides here situated. First of all, I always like to start by a few housekeeping rules. If you've got questions throughout the session about anything that I've said or anything you see on the slides, feel free to pop them in the chat. Kayla Spellsworks here from our firm, and she's going to be monitoring the chat. We did have some questions submitted prior to today, and so we may use those as Kickstarters if we need them. But I'm going to move at a pretty good pace through this content because I am primarily interested in having a dialogue with all of you and answering any questions that you may have come to the session with today. And so I always like to give everybody a good lay of the land before we get started with any kind of content presentation about where we're headed, what we'll be talking about. So 3 basic takeaways I hope that you all get from today's content is a discussion of the missed legal steps that might later either cost you money in your transactions or slow them down, which also costs money, but in a different way. And it also costs you time and costs you advisory fees, whether that's legal, accounting, consulting, or the like. Secondly, we want to talk about preparations you can take today to make your due diligence when you are transaction ready go more smoothly, go more promptly at a better speed, which can also mean a better result for you if you're a selling agency. And then I want to go give you sort of a primer about the deals, the deal points and the documents that you could expect to see in a potential transaction in your future. Of course, your mileage might vary depending on the particular deal you're making and the way you might structure it, but it's a good summary of the patterns that we see in just about every transaction that we help agencies with. What we're not going to cover today, although I'm happy to answer questions about any of these topics when we get to the Q&A session, but we're not going to talk really about valuation, how to value, or what the appropriate multiple might be for your agency. There are other experts that you would need to bring into the mix to help you really make that judgment for yourself, and there's lots of factors that go into it. We're not really going to focus on the deal structure either, whether it is an asset versus an equity transaction, what kind of tax planning things, if you're a selling owner, you might need to think about, earnouts, if you're a selling owner. But I'm happy to answer questions about that because we've faced those situations on many occasions for our agency clients in a transaction. And we're also not going to specifically cover the types of transactions that might be an option for you in the future. And those might include equity investments by third-party equity firms or individual investors. It might include an internal employee purchase of your agency, a merger with another agency, or an outright sale of your agency to another agency, perhaps. So while we won't address any of those things at a broad level, again, happy to answer any questions I can on those things, either today or after the session. All right, first, hi to all of you. I'm not going to presume that you all know who I am or that you've been in touch with me or with any other folks at my firm in the past, but we are Toric Law. We do business in the agency community as legal and creative, and we are a firm founded a dozen years ago to really serve independent marketing, communications, digital, creative media firms that are across the United States and that need help protecting their assets and turning their IP, whatever that might be, your ideas, your strategies, your plans, your creative, turning that into revenue. That's what we do every day, and that's why we do it. And those are the businesses that we do it for. And that usually means one of three things. We're helping you address IP protection, advising you on how to package your IP for monetization, or helping you with enforcement issues. And sometimes that might mean giving you help to help your clients with enforcement issues when it comes to IP. Secondly, contract development and negotiation, helping you put good, strong contract deals in place with your clients, with other agencies you collaborate with contractors, etc. And then helping you with marketing regulation compliance. That might mean something like FTC rule compliance or data privacy rule compliance. So you might be asking yourself, why are we addressing agency M&A then in an agency owner Q&A session? It is because we have seen a dramatic uptick in the last 24 months in M&A volume amongst small and mid-sized independent agencies. And frankly, um, as advocates for agencies, we needed to be in a position to help folks like you when this opportunity comes your way. And so we've probably done about 15 deals in the last 12 to 18 months. And that's a combination of agencies selling to internal people, agencies selling outright to other agencies, and agencies taking on investment. And so we have quite a bit of experience that's recent under our belts here. And what I'm going to share with you are our learnings from those deals and just what we know from observing your industry and working with other consultants in your industry. So if there's anything that running a law firm has taught me, is that hindsight's always 2020. And I think running any business teaches you this. So what I'd like to do is share with you some of the benefit of our hindsight as a firm representing agencies in the midst of these transactions and business situations, and highlight some, first of all, to start, some of the things we wish had been done earlier, or things that could have been done, or steps that could have been taken that might have either resulted in a deal getting closed more quickly, or they might have resulted in a lower level advisory fees when all is said and done. I've heard industry analysis for independent marketing agencies to the effect that your advisory fees all in for an M&A transaction, this is everybody, this is brokers, this is lawyers, accountants, are about 5 to 10% of the entire purchase price of the agency. So obviously, anything you can do to drive those costs and those fees downward is going to leave more money in the selling owner's pocket. And so that's what I mean when I say missed opportunities to avoid extra time, money, and certainly stress. And on one or two occasions, unfortunately, we have seen a deal not come to fruition because of a miss with some of these steps. So learn from our experiences and the experiences of some of our clients by what I'm going to share with you briefly today. So let's talk about some of the major steps that we've seen maybe get missed or maybe get abbreviated, and the result of which was a transaction that didn't move as quickly or as smoothly as we might have hoped. And again, in one or two cases that maybe never came to be, even though the parties spent a lot of time on it. Firstly, poor or missing client contracts between your agency and your clients. This is the 2 points I'm going to discuss with you that you're seeing on the slide now. These are actual, in my view, deal points that will cost you money in the form of the potential purchase price you might garner for your agency. And that is just my opinion based on my experience, but I will back it up with my why as I walk through these. When you're selling your agency, you're selling a lot of things, right? You're selling reputation, you're selling perhaps the skills that your team has garnered based on the kind of work that it's done over the years. But in many cases, what your buying agency is looking for is the value of the contracts that you have in place with your clients. And so, if you have deep client relationships that might be longstanding, but are not reflected in a written agreement that has teeth to it that protects the agency, that is going to be a challenge for you in due diligence down the line. And we have seen this happen. We've seen missing contracts. We have seen client contracts that don't have assignability language in them, either because they say they are outright not assignable, or they say they might be assignable, but you've got to get client buy-in about that, which means which isn't the end of the world, but which takes you time to figure out how to strategize those conversations with those key clients. If your largest client is locked into you with a contract that requires their permission for assignment to a buying agency, you got to talk with them about it. And you may not be ready to talk with them about it. And so you'll need a communication strategy in any case, but it becomes more lengthy and delicate depending on how your contract with them is written. So we've seen contracts that were not assignable. We've seen client relationships that comprise a pretty hefty part of the revenue volume of an agency that are so entrenched with the current owner, perhaps, that they were handshakes at one point, or they were handshakes maybe supplemented by some purchase orders or some statements of work over time, but there's no master terms to them. And so they might be good, strong relationships, but they may be very vulnerable relationships. We've seen agencies still doing business with clients for whom their contracts have expired. Either the brand decided intentionally not to renew, but to continue to throw projects in the direction of the agency, or nobody remembered that the term of the contract had expired and wasn't currently in effect, and the parties were all just operating as if it was still in effect. Great for your day to day, as long as it's not disturbing your revenue today, but not great if your buyer wants to see evidence that this relationship's going to continue after they buy the agency. And then we've seen examples, of course, of client contracts that have what I will say in air quotes have less than ideal terms. And what do I mean by that? They may have exclusivity clauses. They may have convenience termination clauses that are either too short or too long. Not every buyer for your agency wants to keep all of your clients. Sometimes there's, frankly, either a conflict with the current client they have, or maybe there's some dead wood in terms of profitability that they want to shake loose. And so there may be exclusivity language in a client agreement that doesn't align with the buying agency's roster of clients. There may be, there's lots of possibilities. And so you've got to sort of audit, and see where you're vulnerable in that regard, which we'll talk about in a little bit. But so poor or missing client contracts definitely can impact the financial return on a transaction for the selling owner. And it's something that we've learned that you all need to be aware of in advance. And we're going to give you some pointers about that. Unprotected IP. I'm gonna, be completely transparent here about the fact that I am an IP lawyer by training. I'm an intellectual property kind of warrior, and it's one of the main reasons why I started working with marketers and then agencies, because I think that agencies
A buying agency.
undervalue their intellectual property, and also that in many cases, a lot of the value they've built up in their business, um, in addition to the client revenue, might be in their proprietary IP. So when we see misses here, it might look like you don't have trademark registrations of your agency brands, whether it's your main agency name or whether it's taglines that are meaningful in the industry that you serve, or whether it is product name, because some of you productize your services. So no federal trademark registrations. Um, every agency, of course, has a process. Some of your processes, to the extent you've kept them proprietary and secret, they're your trade secrets. And um, that's wonderful and also value expanding for your agency in a future deal. But if you haven't documented them, it's hard to demonstrate the value, and that can cost you money in the transaction. So that is one miss that we've seen in hindsight that I want to make you aware of. Unregistered copyrights in any published IP. What do I mean by that? If you are an agency that also have revenue streams attributed to a software product, a digital course, a workshops that you present to clients in addition to your fee for service work. All that stuff that is copyrightable should be copyright protected. And the more you've done to protect it, the more valuable it is perceived to be by a potential buyer. Take my word for this. I've seen it multiple times. So copyright protection, very significant for any of what I'll call your published intellectual property. And then we've seen very insufficient client provisions between the agency and your clients regarding the IP that you've created. The last thing you want when you are negotiating a deal to sell your agency is any question about whether a client that you've served in the past might have any claim to any of the original IP that you're packaging as part of the deal. All right, some other things that we have seen. Total absence of any owner agreements when the selling agency has more than one owner. Have the current owners even talked about how the sale proceeds are going to be distributed amongst them? You may very well have an understanding, but if you don't, how is that going to be resolved? And it all comes down to what's documented. So there's that. There's the division of the proceeds in a transaction. There's also a documentation regarding decision making. Who is the decision maker in the business? What if one owner wants to sell and the other one doesn't? What happens then? Um, the absence of an owner agreement doesn't necessarily cost the deal, and it doesn't necessarily impact the purchase price for the deal. What it does is draws it out longer. And also, because of the loss of time, can make the buyer a little less eager over time. So missing or absent owner agreements is a frequent miss that we want to make sure you're aware of. Missing or absent corporate records. This one, frankly, is not likely to scotch the deal. It's just an administrative hiccup that will cost you definitely time and definitely money, because you're going to have to fix it fast when you're in the midst of due diligence or transaction conversations. Is your agency in good corporate standing with the Secretary of State where it's chartered? Is your agency in good standing with the Bureau of Workers' Compensation, with the unemployment division in your states, or in any other states where you have team members? So not having a handle on this and not having being able to put your thumb on the information really quickly. And this is as much a financial and a tax thing as it is a legal thing, but that is a miss that we see cost time in these transactions. Also, no documentation, missing documentation, no resolutions at all amongst the owners or the directors of the company about decisions you've made in the past. Things like loaning money to the business from the owner, or making a decision to make a major purchase or sign a major contract for an office lease or something similar. So, where is your history documented about the decisions you've made in the past? Because it will impact at closing how the owners decide to divvy up the proceeds of the transaction. And then missing and absent talent agreements. This is to the sometimes we are on the fence about whether having contracts in place for employees is necessary, depending on the talent that you have at your agency. But if you've got key employees, and if that talent is crucial or important to a buyer, and you don't have contracts in place with those folks, it puts you in the middle between a potential buyer and and a key employee of your business who frankly may not have any obligation to continue assisting in running the business with new management in place. So you want to be thoughtful about having your key employees under contract with the agency. And also, if you're providing them any sort of golden parachute or appreciation rights on the sale of the business, if you've had those conversations with those key employees, those obviously have to be reflected in writing, and stopping so that you can make sure that's all taken care of costs time and traction and legal fees, quite frankly. Independent contractor relationships. This is something that's notable for two reasons. First of all, you want to make sure there's a clear trail between any 1099 talent that you've used and your agency so that you are sure you're fully
Mm.
compliant with any client contract obligations you have, particularly around IP ownership rights and particularly around fair competition issues. Because if you haven't done that, then it's going to be hard for you to represent in the transaction to the buyer that that everything is copacetic on those fronts. So documenting your independent contractor relationships is also a key thing and will certainly raise questions, which again, cost time. And then no employee policies or procedures.
Mm.
The reason this slows things down is because your buyer may not have a full appreciation for what the expectations are amongst your employees, to the extent they want to bring them along, and many times they do. What are their expectations around benefits? What are their expectations around paid time off? How much accrual do they have in place for their employee benefits? So something you've got to sort through in due diligence, but understanding where you are and having it all nailed down in advance is crucial for keeping velocity in the deal. All right, so those are all things that I'm personally testifying to have been issues in transactions that we have worked on at our firm. And again, it isn't that they necessarily all resulted in a different purchase price or that they necessarily resulted in a deal not happening that could have happened, except for in one case. But it is the fact that they made the deals take longer, and the absence of those things resulted in higher fees. I can definitely report that with confidence. So, as we said, hindsight's 2020. Let's think about taking a look ahead. It's great to know what missteps have been in the past, but let's talk about what can you do now today to put yourself in a position where momentum is as smooth as it can be under circumstances like this when you do find yourself in front of an opportunity to perhaps sell the agency, whether internally or externally. And the good news here, and I want to stress this again, even though I said it a couple minutes ago, is that these are things, guys, you should be doing for your agency even if you never sell it. These are things that put you in a stronger position with your lenders. These are things that put you in a stronger position with future clients because you will have looked at your client agreements and known your vulnerabilities. These are things that will have put you in a better, stronger position with your employees and your contractors because you'll have better systems and processes and documents in place. So this makes you stronger and more valuable and reduces risk day to day. So this is not wasted time or effort to be doing this proactively, and not at the 11th hour before a potential sale of your agency. So let's go through some of these at a pretty fast clip so that we have plenty of time for questions. Let's talk about client contracts for a minute. You all should have a consistent approach to how you document your client relationships. Every agency has a unique flavor to it. We have our recommended approach for agencies about how to engage in a contract with your client. But whether you are an agency that uses an MSA or you do a lot of fast project work, so maybe it looks more like an estimate or a proposal with some legal terminology thrown in there, whatever is working for you. And if you don't know whether it's working for you, please reach out and we can help you, work through that. But whatever's working for you, is it consistent? Is it documented? Does everybody understand how to apply it? And there's two reasons why this is important. First of all, it's going to mean you're more likely to be able to produce the pile of client contracts that are a huge portion of your agency's value in a due diligence process later on. But also, you're going to know what your benchmarks are when you negotiate your next agreement a lot more easily if you have your client contract standardized than if you don't. And this makes you more valuable because it's going to help you be a stronger negotiator, even if you're signing a client agreement in the future off of their paper. Why? Because it will have helped you think through your benchmark on things like IP ownership, convenience termination, collection terms, payment terms, exclusivity, assignability. You will have pre-thought these things through if you've got a consistent approach and consistent set of documents. And that means over time, your client engagements should be more well thought out, therefore more profitable, therefore making your agency more valuable. I know it's a bouncing ball that you might be a little bit skeptical about following, but trust me, this pays dividends today and tomorrow if you look at it that way. Also, having a centralized process for approving and tracking client agreements and negotiations is crucial and will make the questions so much faster to answer when you're in the middle of transaction due diligence as well. All right, so that's first. Second, employee and talent contracts. I kind of hammered on this a minute ago. I'm not sure whether there's a ton more to say about it, except for that standardizing is, again, important with your employees. At a minimum, a standard offer letter for new people coming on, and then what we call a standard business protection agreement, which is the agreement you want employees to have with your agency about things like confidentiality, um, ownership of your intellectual property, fair competition, things like non-solicitation. You want to make sure you have consistent approach to this because your buyer in the future is going to want to know that these obligations are sewn up with your current talent, even if they're not going to be bringing them along with you, because some of these obligations last beyond the employment relationship. Your policies and procedures. Even if you haven't taken the step to formally implement an employee handbook, or even if you have and it's been a long time since you've looked at it, at a minimum, you need to be thinking on a regular basis. What do I mean by regular? Twice a year, probably at least, about consistent employee policies that you have in place or desire for your team members to follow and documenting them. Ideally, that's a handbook, but even if that's not what it looks like for you, you need to be writing them out and having someone in charge of documenting them all. These are the money policies, again, like benefits, paid time off, as well as the risk reduction policies that every business should have around work-based behavior, time off, intellectual property ownership, moonlighting, non-solicitation, all of that stuff. Also, put an independent contractor agreement in place. I'm begging all of you. We've done entire Q&A sessions just on working with independent contractors, so we don't have enough time to go into the details of it all today. But for the purposes of making your due diligence readiness more robust, have a standardized process for contracting with 1099 folks so that you are in the clear there. All right, vendor contracts. And I want to encourage you to think a little bit more broadly about vendors than you might be inclined to do. This could be your key vendors in terms of your client service. Maybe they're your data warehouses. Maybe they are your, your website hosting services. It could be your ad buying accounts, any of your vendor contracts. You need to be thinking about assignability and change in control issues so that you know where you stand in terms of being able to assign these contracts and accounts to a buyer in the future, or whether they're not going to be assignable and you're going to need to disclose that to a buyer. So think about assignability and change in control language in any of your third-party vendor agreements. Know what the terms are and know when they expire. Sometimes an upcoming expiration is a good thing. You've got a bad agreement with a vendor. We've certainly seen a lot of them in our day working with agencies. And you want out, and you want to be able to tell a buyer with confidence, this agreement's going to be done by the time you buy us. So it's not something you need to worry about. Sometimes you want them to be, you're locked into a really good agreement, either because the vendor's terrific or because the price you're paying for whatever they're providing to you is very favorable to you. So only you can be the judge of that. The bottom line is no, right? Audit and know where you stand in terms of termination, assignability, expiration. Remember, your office lease is a vendor contract too. For all of you owners who might be on the line who own real estate, hopefully in a separate entity, again, that's a topic for another session, but who are allowing the agency to rent it for its day-to-day business activities, that's a decision for you to make too. And the rental agreement or lease, which you hopefully have in between the two entities, your agency and the entity that owns it, should speak to that assignability or be easily modifiable so that if the buyer wants to continue to use that office space, it's easy to make that transition. Or if they're not interested, that you have a plan in place for what you want to do with that space when you sell the agency business. A lot of agency owners are very diversified in their business affairs, which is a smart thing to do. They've got their real estate separately held. Many of you, I won't say many of you, some of you also have your intellectual property held in separate entities, which is also very smart. Because you may want to sell the agency book of business, but keep the IP. You may want to sell the IP, but keep the agency book of business. So we're not going to talk about structuring to any great detail, but the point is vendor contracts need to be planned around. Loan and debt documents. If you are like most entrepreneurs and you own an agency, may have come times in the life cycle of your agency where you loaned personal funds to the business. And so documentation of those loans to either offset them from distributions or to make certain that you are repaid first on those loans out of the proceeds of a buy-sell transaction is critical. And so you can only prove what you've documented. And so this is sort of a legal and an accounting issue because there's obviously the math involved, but there's the legal agreement in place between the owner and the agency. Also, auditing all of your third-party financial debt obligations is a really smart idea on a regular basis. Who does the agency owe money to? When is it due? When is a loan mature? Which of those obligations are personally guaranteed by the current owner, the selling owner of the agency? You need to know all that stuff. So having it all tied up in advance is an important part of making due diligence go more smoothly. IP licenses and registrations. Again, I talked about this briefly, but I want to elaborate on it just for a minute because I do think it is so critical to the value of every agency. So Make sure you're registering and maintaining those agency brand trademarks. I have seen them definitely make an IP portfolio is definitely a value enhancer for purchase price purposes for an agency. So to the extent you can formalize all this stuff, you can make an easier case for proving how additive it is to the value of the business that you've built and are selling now. So registering trademarks and agency brands, agency product names, agency taglines for its services. Specifically calling out in your client contracts the IP that belongs to the agency and the agency only and is not a work for hire for the client. That might mean, again, your software, a proprietary content library. And it could mean many things, but making sure you've called that out. I think we've got somebody who's maybe not muted on their, yeah, if you could all mute yourselves, that would be really great. Unless you have a question, in which case, let me know. So making sure you understand the difference between work for hire and your own IP, and you've called that out in client agreements. And again, centralize the creation and documentation around your agency's proprietary intellectual property. If you have secret sauce, if you have a methodology or a process, and the value to the agency is in the fact that it's confidential and it gives you an edge over a competitor, it should be documented internally and confidentially. And then finally, as I said earlier, copyright registrations for that externally facing content and intellectual property. Very important to establishing value and sweetening a potential deal with the buyer later on. Corporate bylaws and agreements. I don't want to gloss over this too much detail, except to say that if you don't have them, I think somebody's still not muted. If you don't have them,
right.
Let's
so
get
we've
your
got
bylaws
just a
in place.
small tech office through there.
All right.
Yeah.
Kayla, could you hit mute on everyone?
There's actually 4 bathrooms.
You'll have to unmute yourself, Sharon. Sharon, you're muted.
Okay, I'm unmuted now. I'm going to go back to the deck really fast. Sorry, you guys. We just wanted to make sure that everybody's hearing. Okay. 1 second. Okay, sorry about that. If you don't have bylaws or an operating agreement in place for the agency, please do that. This is just low-hanging fruit. It doesn't take long to do. It's not expensive to do. It increases buyer confidence when you have these in place. And you also want to make sure you've got adequate documentation of decisions that you've made in the past. The important things to really make sure are accounted for when you put corporate resolutions in your book, if you will. Borrowing money, whether it's from an owner loaning money into the business or from a third-party lender. Buying or selling assets, that could be equipment, that could be real estate, whatever it might be. Or entering into any major business agreement, like a strategic alliance, perhaps with another firm, an office lease, anything that's major. If you have questions about what might be major or minor, then, talk to your advisor at the time and mutually make the decision before you go ahead and document things. It's also good to just do an annual sweep up resolution every year of your business so that you've captured everything that's happened throughout the year. Owner agreements. This is separate from your bylaws or your operating agreement. This is a crucial document to have in place, and expect buyers to ask for this if there's more than one owner in your business currently. They want to know, do you have an understanding between you all about who can make decisions and also how the proceeds of the transaction are going to be divided? They don't want any signs or signals that that's going to be a red flag later on in the deal. And so this is something that while you have the benefit of time and planning, you need to sit down with your business partners and hammer out and put in place so that it makes the decision making and also the clear path towards completing the transaction more prominent later on. If your agency has in place benefit programs for your team members, which is highly likely, I've yet to see an agency that doesn't have really anything in place. So, benefits documents, profit sharing arrangements, phantom stock arrangements, appreciation rights. Your buyer is going to want to see what have you promised to the employees? What are their expectations if we want to take them on? Because these are crucial to their decisions about whether they're going to take your team members with them or not when they buy your business. And I have talked to many agency owners in this situation over a year who they really want to protect their team members. And one of the ways to do that is to be very thoughtful and also expressive in writing about what their participation might be in a transaction. So have clear and current written documentation of all your benefits, all your plans that are in place. A buyer is going to want to look at these and they're going to look at them pretty closely. Your key employees in particular are also going to depend on these to protect them in the event there's an owner transition and they want to move along with the business. And that usually shows up in the form of something like either a golden parachute where they can leave under certain circumstances or an appreciation rights understanding where they're going to get an upside if the business sells based on their participation in the business for a certain amount of time. Again, work with your advisors to help understand what you have in place, what you should have in place, and what documents are appropriate there. All right, so we've talked about sort of challenges we've seen agencies have in these transactions. We've talked about due diligence plans that you should be thinking about now so that you can get your house in order for a potential future transaction. Let's talk about the transaction itself and what you might or should expect in terms of legal documents and legal process once you're in front of an opportunity. Everything we've talked about up until now, these are things you should start thinking about when you have a bit of a horizon between you and this decision. And the next section is really about, okay, we're here. We've dated or we're dating, and now we think we want to talk about making it permanent. So what should you expect from a legal perspective? First of all, let's talk about the actual purchase agreement. This is usually the first step. It's usually the second or the third step in a transaction. The first step should be a mutual non-disclosure agreement, because before you start letting a potential buyer peek behind the curtain, or if you're a buyer before a seller should want you to start looking at its business hard, you want confidentiality understanding amongst everybody involved. So the NDA typically first. Many times we're going to see a letter of intent be that second step. It doesn't always have to be, but sometimes you can go straight to the purchase agreement, but many times the LOI is a necessary next step because it flushes out any potential misunderstandings about what the major terms of the deal are going to be. And it also helps the parties understand, is there a true meeting of the minds or connection here about how we want this transaction to go, and what the major components of it are going to be. So non-disclosure agreement, letter of intent, and then the actual purchase agreement. This is either going to look like a equity purchase agreement where the buyer is buying all the stock, if you will, or all the membership units if you're an LLC of the agency's business, or it might be an asset purchase agreement, which is more frequent in my experience. I'm not going to say it's more common or not. I'm just going to say that we've seen more asset purchase agreements than we've seen equity purchase agreements. The basic difference between, I'm sure I'm telling you something you already understand, but equity includes the assumption of also any obligations, debts, or other risks that the agency has had. You can exclude some of those things again, so it's a very general statement. But asset purchases are just that. You're buying the assets only. A book of client revenue, a portfolio of intellectual property, specific pieces of intellectual property, again, that have ongoing revenue. They'll be identified and listed very specifically in the asset purchase agreement. Typically, it's important to know that this is where you're also going to spell out any fair competition covenants for a departing owner. A buyer of an agency always wants an understanding in writing with the departing owner about what sort of business activity they plan to engage in after they leave the business. It used to be that these deals occurred in conjunction with a selling owner's plans to retire. That's not always the case anymore. Sometimes a selling owner wants to found another business. Sometimes a selling owner wants to establish an adjacent business to the former agency, or they may want to take the IP that the agency's developed and set up a separate business to leverage that. Whatever the case, the buyer's going to want an understanding of whether or not the selling owner can continue to work in the space and for how long they need to stay out of it if that's not the case. I have yet to see a deal that does not include a non-competition covenant in it for a selling owner. And unlike non-competition covenants for employees in many states now, non-competition covenants in an arm's length transaction between a buying agency and a selling agency are completely fair game. They are enforceable. They are an arm's length negotiation between seller and buyer. And I have yet to see a transaction that doesn't have them addressed in some form. So those are the components of the actual purchase agreement that you'll expect to see. You may see a bill of sale. This is kind of a remnant because M&A deals are kind of treated similarly from a legal perspective, regardless of the industry. And so agencies don't tend to have a lot of hard assets, a lot of hard equipment. Some of you do, though. Some of you have production equipment. We've seen entire warehouses of production equipment for things like experiential agencies who do a lot of installations and things, video equipment, etc. So the point is that the bill of sale is typically used to address transfer for hard assets, and also you might include soft assets like your intellectual property if they're not included in a separate assignment document. All right, promissory notes and loan documents. If the seller is going to be financing part of the deal, or if there is a buyout, a structured deal, then you're going to see promissory notes. You're going to see perhaps security agreements, a stock pledge, something that will give the seller who hasn't been cashed out at closing some leverage to enforce against the buyer if they're not fully paid what they expect to be paid. You're going to also see personal guarantee expected in many cases of the buyer's owner, that the seller's owner is going to be paid out the purchase price that's been agreed upon. All right, assignment documents. I covered this a second ago in bill of sale, but to the extent any of the soft assets, generally intellectual property, are not addressed in the bill of sale, we might see that in an IP rights assignment. And we'll also typically see the actual client contracts, vendor contracts, any leases or licenses, those covered in a separate assignment document. And these are the kinds of things that are incorporated as exhibits to the main purchase agreement. And then finally, a transition services agreement or possibly a consulting agreement. Even though the buyer is going to want the owner to make some promises regarding fair competition after they leave the business, most times they're going to want the selling owner to stay around or be available for a period of time. And we've seen these done one of two ways, either a personal consulting services agreement with the actual owner individually, or a transition services agreement where the selling agency or some other legal entity that the selling owner has set up enters into a contract with the buyer to provide transition services. And those can be things like hand-holding of clients, or dealing with the administrative transfers of employee benefit accounts, or just think of all the things that naturally occur when you are handing over a business from one owner to another. And typically we see those anywhere from 1 to 3 years. Although we've seen them as short as 6 months when a selling owner is really eager to just hit the road and be out of the business. These are some agreements I don't want to spend a ton of time on because they're not, they don't pop up in every single transaction, but individual guarantees in a leverage deal, I touched on that a minute ago. Stock pledges. This is one of the mechanisms that might be used to help a selling party recover money if the buying party doesn't meet their payment obligations. We've unfortunately seen selling owners have to leverage these to either take an agency back when the buyer didn't pay, or extract faster payment when the payment was past due. UCC filings, these are filings that you can make to enforce a security interest against a buyer who doesn't pay. You might also see or be a party to new company bylaws or charters, new owner agreement, buy sells, or lease assignments. Some of those are on the buyer side, not the seller side, but these are some of the things you can anticipate. All right, so I've gone through a lot and I want to leave time for questions. So what do you do next? This is, this is great, Sharon, but what are we supposed to do next with all of this that you've shared with us? So 3 steps here. Take time, use your horizon. Hopefully you are at the beginning of a consideration process regarding of all this and not up against it, but do an audit. Where are you right now? Look at, use the template we've given you, the playbook, if you will, for creating your own plan to sort of look at the business step by step and area by area and figure out where are we missing the mark, where do we need to be stronger, and what will make our lives easier once we want to start having these conversations. And then as you do that and try to figure out your action plan for how to address these, what's important to you? Does your agency have a lot of IP, you think, but it's undocumented? Start there. That might be the best place to impact your future sale price, is by documenting and packaging and presenting your IP in as lucrative a fashion as you can. Has it been a long time since you've updated your client agreements, or do you have a firm understanding of when they expire, where they're missing, what provisions might have to be explained away to a buyer, or what conversations might be more challenging for you to have or take time for you to have with a client whose business you want to hand over to a buyer? Whatever your priorities are or whatever your gaps are, make a plan to address those gaps. Work on one area at a time, schedule the workout, um, centralize this, I would say, within your agencies, but consider this a team activity. If you're an agency that has maybe a layer of management that can help you in various areas, like an account director who might be able to lead the charge in terms of auditing your client agreements. If you have a COO or a CFO equivalent, they can look at some of the financial aspects of it. But look at your lead time, look at your priorities, and make a plan. And we've got a QR code here, which is also on the next slide, which is going to take you to our resource center, which has got some free tools for you to think about. One of them is an actual checklist, a due diligence checklist for agencies to use, and use that as a template for your playbook, so that you've got a place to start. So you can think about this systematically rather than sort of take a scattershot approach or a fear-based or a sort of, things are on fire-based approach to being ready for a potential acquisition opportunity later. So I want to make sure I get a chance to say thank you all for being here. We do have time allotted for questions, and I know we had some submitted either in advance. Hopefully there's 1 or 2 in the chat. Again, this is the link to our resource center. There's the checklist, there's some other content there. And there's also a replay of a workshop that I did with Marcel Petitpas over at Parakeeto, which is a consultancy that focuses on agency profitability around M&A and how to maximize the financial value of a potential M&A. So I'd encourage you to take a look at that as well, because we dealt with it from both a financial and a legal perspective. So with that, I'm going to take a pause, and Kayla, I'm going to ask you to unmute if you're not already unmuted, and if we've got questions, I am all ears.
Yes, we have some questions.
Okay.
The first question is from Michelle, and she wants to know, what is the process, timing, and costs associated with copywriting a process or a workshop?
So that's a great question. And the way we look at it is by figuring out the most efficient way to package the IP so that because the way that our firm handles copyright registrations for agencies is by application. We're flat fee, and so it's in everybody's interest for us to figure out how to package your IP in as few applications as possible to the Copyright Office. So that's going to depend upon whether or not you released it to the world all simultaneously. And what do I mean by that? Some courses or some digital content is released on drip, which means we have different publication dates, which means different applications, which means more money. So we like to combine it in one application. And so I would focus on how many products do you have? Do you have maybe 3 major courses or 3 major bodies of work? Then we would try to get it into 3 applications. And I'm happy to talk with you, Michelle, offline about what that looks like. But basically, we would put together your copyright registration application based upon the package of work we're protecting. Whether that is video, audio, downloadable digital assets. The goal is to throw it in as few applications as we can, so that we obtain registration of that piece by
Thank you.
piece. Hopefully that helps.
Thanks.
Yeah.
All right. Dave is asking, help us understand what should be protected by registering a trademark or a trade name. Is it the company name, logo, or some specific tagline that is used?
I think for most agencies, the truth is that for trademark purposes, anything can serve and be protected as a trademark, so long as it identifies the agency as a source of a product or a service. So what do I mean by that? The agency name, Dave, just as you pointed out, the agency tagline, the agency visual presentation of its brand. Usually that's a logo or a stylized type font of the name. For most agencies, again, your mileage may vary, and for many of our clients, they have packages of trademarks. They actually have the basis for more than one registration. But I would start with the name, because for most agencies, the protection of the actual literal name of the agency is what makes them stand out as unique, or what they want to go to market with as being noted for and notable for. So I would start there. So that would mean the agency name. Sometimes there are benefits to focusing on the logo, either along with or separately from the name. If your name is popular, let's just put it that way, and is not as exclusive, but you might be first to market with it. And then I would focus on taglines. Taglines are important, and they expand the value of your trademark portfolio. But in my experience, they're not typically as crucial as the main name of the agency. So I would triage it that way. Name plus logo, then taglines. Great question.
All right. Michelle had one other question. How would you handle sellers who want to further negotiate or sweeten the deal after an LOI is signed?
Well, I would unfortunately say to you, and this is sort of a facts of life answer, this is not uncommon. However, a seller that comes to the table after a signed LOI is in place and wants to adjust one of the material terms, I mean, one of the major deal points that you've agreed on, like price or, payment horizon or structure of the deal, should come to you with a really good case for why they feel like an adjustment is appropriate. It's not always unreasonable for the seller to do that, but they should have a good story for why they want it to happen. Either our revenues this year have dramatically upticked from last year, and the financials you have in front of you are not reflective of what we think the current value is, or we have this major event on the horizon, which means that, we need more money, or that we want more money up front and less structure to the deal. The point is, if they're gonna, if it's not a super material term, then I think you have to gauge whether it's worth, spending a lot of time battling back and forth about it. If it isn't gonna really materially impact the value of the transaction to you. If it is a major and material term, then they should have a good story, and it should invite a very, detailed conversation between the parties about the why of it. I wouldn't automatically make an assumption that they are being inappropriate in asking, but I would ask a lot of questions as a buyer.
Right, I know it is 2:01 now, and we do have a couple more questions. Do we
I'm
want
gonna
to
stay
answer?
around. Anybody who needs to leave, I totally understand. And just to answer the question about the recording, which we always get, and maybe that's one of your questions, Kayla. Everybody who registered is going to get a recording of the session, and so I'm gonna hang to answer every one of your questions. But I totally understand the value of everyone's time, and so if you've got to jump off, thank you so much for being here. Really appreciate it, and be on the lookout for some messages from us afterwards with the recording, etc. And with that, Kayla, I am going to hang out and answer everybody's questions. So let's have them.
All right, great. Mark wants to know, is there additional compensation for signing a non-compete based upon the length of a non-compete? Or is it assumed just as part of the overall transaction?
No, that can definitely be a deal point that impacts the amount of consideration that a seller requests. Um, as I said earlier, these aren't just retirement deals we're talking about anymore, guys, right? A lot of time it can be an owner that is simply still in the prime of their career and wants to do some other things, and maybe adjacent to what they've already done or the reputation they've established. Um, so if the buyer wants the agency, but they don't want to pay as much for the agency, or they want different payment terms of the agency because the selling owner wants to still stay in the mix, then I think that it absolutely is a deal point, to be negotiated, and it can impact the financial terms of the transaction. So that is an arm's length, and it can be a material deal point, depending on the individual brand or reputation of the owner themselves. A lot of times your agencies, if you are small or mid-sized independent agencies, frankly, they balance heavily upon the reputation of the owner. And so the owner leaving, um, can be kind of a big deal. And so that makes that a fair, um, negotiation point between the selling party and the buyer of the agency.
All right. And then Bruce is asking, how long does it take to register a trademark and how long process an IP?
Well, you're not going to like the answer to this. So if your trademark is established and in use, then we don't have to file based on intent to use on your behalf. So that means that greatly abbreviates or potentially abbreviates the process. It is taking right now the United States Patent and Trademark Office about 8 to 10 months to take a first look at a filed trademark application, which is why I want you all to start early as possible to do this. If you've got a few years of horizon, on your plate between today and considering a transaction, then get this started immediately so that it's out of your way. Um, if you don't, then at least get the filing underway so that it can process while you're having conversations. So it takes about 8 to 10 months for initial examination. If an examiner has questions about the application, that can, depending upon how substantive those questions are, that will add months to the process. In general, you can count on it taking at least a year from the time the application is prepared and filed and a potential registration. Volume is high at the trademark office, and it just is a fact of life that at least you can say during the negotiation you have a pending application, and that application can be assigned to the buyer, and sometimes that is good enough for the buyer.
All right, and
That's
our
what I
last,
wanted to hear.
Hey, Bruce.
Thank you.
and for our last question, which I think is a great question to end on, for client contracts, is a PO sufficient in your experience? We have many government clients who issue a PO when awarding contract. I don't see how I could get them to sign a separate contract. Some issue a statement of work, but most do not.
I would say if that is your reality and you don't realistically believe that you can get those existing clients to adopt a more robust set of contract terms and conditions with your agency, I would question that assumption, first of all. But that is truly your belief, or if you're unwilling to have that conversation with them, I would say the next best thing for you to consider doing is incorporating some legal terms and conditions into the PO or the SOW itself. I know you're not going to like that, but if you're not willing to sort of go to the mattress to get an actual master service agreement or professional services agreement, then your second best option is let's make the tools we're already using a little bit more robust. It's less likely to cause drag with the client, but it shows that you've been thoughtful about protecting the agency once you have to present these contracts for review and due diligence to a buyer of your business, right? Which is what we're talking about here. And so I get the tension between the two goals. You don't want to cause friction with existing and probably really long-standing and positive client relationships, but if you're thinking about them as assets, as tools, and preserving their value for a potential future transaction, then think about how you can incrementally make them more robust. And the best way I can think to do that is to start adding more legal terms and conditions, not willy-nilly, but the things that really matter to you, like exclusivity, assignability, you know, convenience termination, those sorts of things as part of the terms within the context of a PO or an SOW.
And that is all the questions.
Wow, those are some great questions. I want to really thank everybody for making the time. I hope this has been helpful to you in sort of making your plans or setting your horizon. And the earlier the better that you start working on these things, a lot easier and less expensively. You'll be able to manage them once an opportunity shows up in front of you. So from me to all of you, thank you so much. For those of you who I know we have client relationships with, we're so grateful for all of you, and thank you for being here today to listen to the content. You've got my contact information, you've got the link to the resource center, and we'll also be sending the recording around as well as some other things to help you along the way. So until then, feel free to reach out if I can be of help, and we appreciate your time today.